Item number 20, delivery of order.
This bail petition is prayer for bail is rejected. Mr. Saikia, there's something which I have to ask you. This matter was heard yesterday. This is the Assam Secondary Education Provincialization Service Rules 2003. I'm just showing it to you. Page 368. Mr. Sharma, please be here with the Learned Advocate General. Just a moment. This is Assam Secondary Education Provisional Service Rules 2003. You see, now in yesterday the matter was heard. The matter relates to appointment of a junior assistant in a provincialized school. Now 4th A1, which I'm showing it to you.
Yes.
You'll find that for class 4 post so and so, selection committee constituted under the provisions of Rule 8C.
8C, yes.
Correct. Now please turn over the page. Page 372.
Yes.
Now this 8C you will find down below in the footnote. It was amended and it was substituted. Now 8C is no longer there.
8C.
Now what has come is 8234. Correct?
Yes, Lord.
But that has not been amended. Now the issue which has arisen is that there is an OM of the Education Department saying that the selection is to be done in a particular manner. Then on top of it, there's a circular issued by the Director of Secondary Education that it has to be done in this particular manner. The challenge is that the constitution of the select committee was contrary to the rules prescribed. So therefore, once the argument is that once the act says it is to be done in a particular manner, the OM cannot override the statute
Yes.
and the rules framed under 309. So now I'm faced with a situation nobody pointed out.
Yes.
And now while writing the order, I found this discrepancy that 8C itself is not there.
8C is not there. This recruitment is grade 4. It
Yes.
is in that category of 1 lakh appointment. If it is
No.
like
Prior to that, this is 2016 matter.
2016 matter.
Now
Because subsequently, when we are having constituted the commission also for recruitment now for grade 3 and grade 4 post, all the new posts are done through that.
now there are two things which are going in my mind. Number one,
Lordship.
is it permissible for the court to read
Yes.
the rules as if it is not 8C, but it is the provisions of 8, number one? Because if that interpretation is taken, then it would mean that the constitution of the committee by OM would have no value. OM will not override the 8C if I read that. So this is a situation where I am faced with a dilemma because nobody pointed out. So yesterday it couldn't be clarified, but since you are there today, I thought I would pose this question. I don't need an immediate reply.
Yes, Lord.
Because then this order I will not release today. That last operative part I couldn't make out because of this. So post is some other day when it is
Yes.
convenient for you to.
Yes. If it is convenient on 11th or 12th of this month, Lordship.
12th.
12th.
Okay, then right.
It can be on 11th also, Lord.
11th also.
11th.
Okay. Okay, yesterday you'll find the large names in the file, huh? I'll transfer. In view of the reference to section 8C of the 8C in section 4A1 of the Assam Secondary Education within bracket provincialization bracket close service rules 2003. And having noticed that the erstwhile rule 8C was substituted by Assam Secondary Education within bracket provincialized bracket close service with again within bracket amendment bracket close rules comma 2012. The court is inclined to request the Advocate General Assam to clarify the legal position. Accordingly, Counsel D. Cycle and Advocate General, who is present in court, has been requested to look into the matter and in respect of the legal position arising thereof. Next paragraph. Accordingly, list on 11/4/2023 for further hearing. Okay.
Deeply applies. I'll make my submission on that.
Yes, mention, if any.
So item 20
Yes.
was there. No, sir, I beg to mention item number 14. Well, CD has not come, my lord. So, well, the
Update CD is confirmed.
Okay, we want it when?
on my lord, 10th, my lord.
10th. List on 10 through 2023, so as to enable Mr. MP Goswami and APP to produce the updated case diary. Okay.
Lordship, I'd like to mention item number 11, Lordship.
Yes.
Lordship, kindly adjourn this matter till verification.
Just point, there's something in this file.
Actually, Lordship, matter may become infectious. We need instruction.
Okay, that's fine.
He was
Okay.
at 11th minus
11th. Okay. On the prayer made by Mr.
D. Kolita. D. Kolita.
D. Kalita, counsel for the petitioner, the matter stands adjourned today to enable him to obtain instructions as to whether the matters become infectious or not. Please start to ensuing view vacation.
To mention item number 5, Your Lordship. Your Lordship, my senior, Mr. Hasibur Rahman, so is not not in good health. That is why kindly adjourn this matter.
Okay. Okay. You're taking consent of the other side? No, then wait for return. No adjournment, ex parte adjournment. Yes,
Lordship, I beg to make him for a listing of repetition on 19th promotion.
on 19th. Give to the court master.
Like,
Item number 21.
Yes. I've just listed this matter because for quite a long time I could not deliver the orders. So this was listed because I could not deliver the orders in appropriate time. So just clarificatory hearing and then both sides are duly represented, including senior counsel for the applicant and the opposite party. So as order could not be delivered for quite some time, the matter is heard again. Reserved for delivery of orders.
Highly obliged.
I'm sorry, this few
No, no.
days I've defaulted.
Item number 1 for Mason. Item number 1.
There is no representation from the petitioner. The petitioner was absent when the matter was previously listed on 21/10/2019. It is also noted that the additional affidavit, which was required to be filed pursuant to order dated 4/5/2019, has not been complied with. So accordingly, the court is of the considered opinion that the petitioner may not be interested to pursue this requisition. Accordingly, this requisition is dismissed at the motion stage for non-prosecution.
For admission, item number 2.
May I please, your lordship?
Yes,
Lordship, similar case earlier, lordship passed an order to make a party Ministry of Education, lordship. So therefore, I'm very times.
okay. Both sides are represented. The learned counsel for the petitioner seeks for his granted time to implement the appropriate and necessary party as responding in this writ petition. This after view vacation,
Yes.
this after view vacations.
I'm appearing for petition.
I said all present.
3.
May please your lordship. My lord.
Yes.
The petition is relating to compassionate appointment lordships.
Yes,
Father died on
2017.
2017
Yes,
and submitted application on 12/12/2017 lordship.
yes.
Lordship, my humble prayer, the matter may please be placed before the next sitting of DLC, Hubri lordship. That is the prayer I have. Died in heart.
Yes, go for today. Just one, you can call back Mr. Nayak. This is BTC matter. He was just here. Wait for some time. He just left. His name is not there in the cause list. After some time, Mr. P Nayak, Mr. P Nayak, SCBTC.
It's from Dhubri district, my lord. This is from petition.
I don't.
Is it?
District lordships. Respondent number 4, Deputy Commissioner cum Chairman.
Oh, okay. Oh, acha, Mr. There's somebody name shown P A Nayak. I thought it was you. And I called you back. You're not there in this matter. Okay, this name of Mr. K Nayak is reflected. I thought it was you, huh? Okay. Yes. So we sent to the authorities. This is 2018 matter.
Not actually our name is not on in the post list, so I could not go through the brief, my lord.
Okay.
G Assam is not shown, my lord, item number 3. So I could not go through, my lord. Otherwise, my lord, whether it has been placed or not, my lord, without instruction right now, I cannot make any submission, my lord.
Okay. Also, the review presented. Mr. G. Pegudan, and government advocate, submits that as GSM is not reflected in the cause list. He is not ready with the instructions. Next. The registry shall reflect the name of GSM. For respondent number 4, let's see the matter next. List on. Make it after vacation. And 19/4/2023. 19/4, you just note the date.
Can it be 20, my lord, 20, 99 not be available, my 20,
So then 21st, 20 is a Thursday,
21st,
21st.
let me say. Extra copy.
Give me extra copy.
I shall serve. Thank you.
Or
My place of lordship.
Yes.
This matter become infractious lordship, my disposal.
Okay. Upon instructions, Ms. P. Saharial and counsel for the petitioner submits that the matter has become infructuous. Mr. E. U. Sharma and its standing counsel for the secondary education department is present. Matter is dismissed on. Sorry, matter is closed, having been rendered infructuous.
I
It's paying for adjournment.
My lord,
Mr. Rahman, standing counsel is not well.
my lord. Even I am also recovering, my lord.
What has happened to you?
Lord, high fever and some cough problem also.
Oh. Also, including the counsel for respondent number 3 are present. The learned counsel for the petitioner submits that Mr. H. Rahman, senior counsel, who is living in the matter, is ill. Mr. Accordingly, matter stands adjourned today. List after answering BO patients. This is of that secondary education department,
My lord, higher education.
higher education.
Higher.
Anybody is there?
Lord,
Higher education?
A. Gogoi was present in the court, my lord. I am for the respondent 3, my lord, private respondent.
Yes, you have filed an affidavit.
Yes, yes, my lord. The higher. Item 5.
What has happened to the criminal revision you have filed? Criminal petition?
My lord, it was allowed, my lord, that the FIR was quashed, my lord.
FIR was quashed.
Quashed. And my lord, there are series of criminal cases filed in one. I got acquittal also, my lord. Trial court.
Okay.
And my lord, in this petition is, my lord, has said to be filed by the governing body president. But my
No,
lord,
that is okay.
Well,
I was looking for something else.
well.
Have you bought any stand on records? Because your affidavit is not there. You have made any inquiry in the matter? Okay. I'm adjourning it, but I just wanted to know.
Yes, sir.
Because this matter is pending since 2018. Just wait for some time. I'll adjourn it, but let me understand. After some time. I'll adjourn it, but just I wanted to
Right.
understand. 2018 matters. And mechanically, I don't want to adjourn it.
see,
Obliged.
And what about your status? You are still there.
My lord, I am serving. My service has been provincialized and pursuant to this honorable court's order, my lord, I am getting my salary and subsistence allowance. I have been subsequently reinstated also.
Okay.
My.
Is item 6.
Right, please, your lordship. And this is the second time, let me now please before your lordship, my lord. And this honorable court has already passed an order, please 19, my lord. Directing the responding authorities to place the case of the petition of issue of the DLC. And that order, my lord, will find case 19 onwards. And thereafter,
Yes, what is your stand? Is case that it was
My
erroneously
lord,
placed?
matter is listed after 2018, my lord. We have not received extra copy. And as per the DLC my notes, my lord, it was rejected because the application was submitted after 1 year, my lord. Which is the necessary criteria under the 16/2015 OM, my lord.
No, the case of the petitioner is that it was wrongly written as 5/11/2014. He says that it is submitted timely.
But then to that effect, my lord, let me obtain the instruction, my lord, because it has come after 2018, my lord, so we cannot track this case, my lord. And extra copy not yet served, my lord.
Okay. You take his phone number. The best time to ask him for copy is 2:33 in the morning. He'll then remember and give it to you. Correct.
can it be after vacation, my lord?
It will be going after vacation, but both sides will be presented on the prayer made by Mr. G. Pegul and government required. Matter since adjourned today to enable him to obtain instructions. List on 26/4/2023. So according to you, it was submitted when? That compulsory appointment prayer
26/9/2011.
11, my lord.
11. But in the document you have annexed, your date is shown as 2014.
My lord, my lord, will find there are two documents. Initially, my lord, that has already been mentioned in the earlier order also. And in this subsequent order, when the notice of motion was issued. In both the orders, my lord, it has been reflected that it was submitted in 2011 itself. But 2014 is a reminder, my lord. That we have that was 6 weeks time, my lord.
Okay.
2014, because 11 it was there, should be better. Subsequently, nothing has come forward. Then 14, my lord, the reminder application has been
Okay.
filed.
Okay. Because I thought 2014. And then I did not read any further.
Right.
In the document 2014 is written. Therefore, after that, I did not read any further. It's okay.
My lord, 2014, my lord, page 15, my lord, will find.
Maybe I don't remember the pages, but there is an endorsement in the lower side of the paper.
Yes, my lord.
Okay.
7 to 9.
I appear in 9, my lord. Because
Junior assistant is a promotional post.
my lord.
Junior assistant. This is.
No, I don't know whether this other two cases, my lord, how they've come to be tagged, my lord. My case, my lord, was with regard to my lord. Grade 4 post, my lord. So, my lord, it's not similar, perhaps. And my lord, in my case, my lord, whether I don't know whether anything still, my lord, survives. Submit case, my lord. Grade 4 for grade 2 almost.
This is Ministerial District Service Establishment. Yes.
They are seeking promotion from grade 4 to grade 3 post lordship in item 7 and 8.
Junior assistant is a grade 3 post.
Yes.
87.
Mine is similar on the other hand, for appointment in grade 4 post, advertisement on grade 4 post. Not so therefore this matters
Wrongly tagged. That means.
wrongly tagged, man.
Okay.
Lordship, the respondent number 2 has filed an affidavit in this matter. Lordship,
The petitioner.
Just a moment.
The-
191. This Assam minister, because you see, I was asking the question because of the fact that 1967 rules, the post category of post, the junior assistant is the last one. How it can be promotional post? That is what I'm asking the question.
Lordship, I don't know, they make a statement in the, they made a statement in the affidavit that the promotion is done as per the ministerial rules, Lordship.
No, you see, they may have said something, but junior assistant in the service rules, he is the last of the post, so he can't be promoted. It has to be a direct recruitment, supposed to be filled up by direct recruitment.
Lordship, rule. 6. Lordship, rule 6(5).
Rule 6(5), note 1. Rule 6(5) is direct recruitment.
Rule 6(5)(b), Lordship,
Is direct recruitment.
B5(b). Subsequently, these rules have been amended, Lordship. Probably in this book, this amendment is not yet been incorporated, Lordship. And the requirement is, Lordship, degree for that promotion, Lordship.
I don't think they have tinkered with rule 5(6)(5). Because the amendment is made by inserting rule 7. After rule 7, rule 8 has been incorporated.
Paragraph 8 of their affidavit, Lordship, they have stated that.
Yes, you are there, Mr. Katania. What about promotion? How can a junior, the lowermost, lowermost post, there will be a promotion?
In fact, my lord, his claim is based on a incident that someone has been earlier was promoted, my lord.
No,
But that was cancelled, my lord.
No, but you see, in your affidavit also, you say the same thing.
Yes.
You say this promotion. How can the lowest post be filled up by promotion? As per the rule, junior assistant is a lowest post. Is there anything below that?
No, my lord.
Then
My lord, 1997, this is a direct recruitment to the class 3 and class 4 post, my lord.
So this is what I didn't understand. I stopped reading. No, that you will not find here. You will find from the rules. The rule says that it is the lowest. In the lowest, I don't know, grade is not written. It just says the ministerial service rules. It just refers to the last post. Yes. Okay, yes. Assam Ministerial District Establishment Service Rules. You take this book. Yes, that page. Yes, no, previous page. Yes. Last entry is junior assistant.
Yes, my lord. Entry 5
Yes, so how can this, there can be somebody lower than that
can be promoted.
for promoting? You better put up a better particulars. We can't spend the time here.
Yes.
This puzzle book. Let your director file an affidavit. For Mr. N.P. Sharma and counsel for the petitioner. And Mr. N.J. Khatuniya and standing counsel for the secondary education department. It is claimed that the petitioner is an aspirant for being promoted to the post of junior assistant. It is also projected that the service conditions of the petitioner is governed by the provisions of the Assam Ministerial District Establishment Service Rules, 1967. Accordingly agreed by the issuance of advertisement to fill up 67 number of posts of junior assistant by direct recruitment. This requisition has been filed. The learned counsel for the petitioner has referred to a statement made by the Director of Elementary Education from Assam. It's elementary, not secondary, elementary education Assam. Wherein in paragraph 8 thereof, a reference is made regarding promotion from grade 4 to grade 3. And reference is also made to the amendment rules of 2015. On a perusal of the Assam Ministerial District Establishment Service Rules from 1967. Comma. The post of junior assistant appears at clause Roman 5 of sub-rule 1 of rule 3 and in the header, the code does not, the said rules has no post of the cadre below junior assistant. Next, accordingly, the director of elementary education Assam is directed to file an additional affidavit in opposition.
Let me come, can we come to rule 6B, my lord?
6B is promotional quota, but you see, he is asking for junior assistant. You must show someone who is below that. Because we I can't quarrel with officers of the education department who are supposed to be more learned than me. His claim is for the post of junior assistant.
Yes,
And the director is writing about promotion from grade 3 to grade 4 to grade 3.
But in fact, the post of LDA, here earlier it was LDA, my lord. Subsequently, it has been renamed as junior assistant. In 2015, I think it has been renamed as junior.
No, I understand. Just look at the claim, his prayer. He's asking to set aside the recruitment process
Yes,
for the post of junior assistant. He says that I am entitled to be promoted.
Yes.
And this is what your director says.
you will clarify it, my lord.
Full stop. Full stop. Moreover, the director of elementary education Assam shall also justify and or explain the meaning and purport of statement made in paragraph 8 of the affidavit filed on 16/5/2019, keeping in keeping in mind the nature of prayer made in the writ petition. The affidavit shall not be filed by any authority below the Director of Elementary Education Assam. Based on 3/5/2023.
Can I point out one more thing?
Yes.
At paragraph 7, Lordship will see that they say that Lordship, they do not have any rules of their own Lordship. At paragraph 7 of the affidavit, Lordship. There is no statutory rules or executive instructions with regard to selection and appointment of grade 3 posting. That is what is being contemplated, Lordship, in the affidavit. But they also say that these rules are being followed. Lordship. the bottom, bottom line lordship. Paragraph 7. These rules, lordship, are meant for district at rule 2, sub rule 4, lordship will find it that it's applicable to ministerial staff in the offices of deputy commissioner, sub-divisional officers, and sub-deputy collectors of the district.
So according to you, which rule is being followed?
Lordship, at paragraph 8 of my reputation, lordship,
Yes.
stated that they were being promoted from grade 4 to grade 3, lordship.
No, you can't have this claim. Once you say that you are attacking the post of junior assistant,
Lordship.
can you have any claim on the promotional post?
Earlier promotions were made as per the directions of the authorities, lordship.
No, but that is what I'm asking you. We just have to clarify what is the post below junior assistant,
It's grade 4 post only, lordship.
but where it is, it's not a cadre post.
No, lordship.
So if it is not there, you can't be promoted. Then your reputation stands dismissed, whatever the stand is taken by the authorities.
Lordship, I had referred to earlier promotions, lordship. They did not refer to any rule there in lordship, and.
No, but that will be, if you see, if the rules does not permit it,
Lordship,
then there is nothing more to be examined. Then whether somebody has got the promotion earlier will not amount to a correct procedure. And there can't be a negative equality.
Lordship, there are judgments, lordship, where it is being said that the procedure that was followed earlier is to be followed in subsequent promotions also, lordship. And lordship, for that, if there is no rule, lordship, or any executive instruction, then lordship, the thing that was followed earlier should be followed in the subsequent promotions or subsequent actions. Also.
Show me.
This I have, but it's not the correct of the lordship. Paragraph 8 and paragraph 10, lordship.
Okay. Mr. Khatuniar,
Yes, ma'am.
then I find merit in his submission. I'll, in view of this, 8B. Sorry, this. 6.5. Note. 6.5B.
Yes, ma'am.
The matter has to go back to the director to take a decision and then fill up the post on the basis of seniority from merit amongst grade 4 staff who has passed the requisite qualification.
But, it was rejected, my lord. In our effort, our stand is, my lord, he has not the requisite qualification of graduation, madam. That is the stand in our affidavit, madam.
Show me that rule where is it is amended, 8B is amended. Where is that? You have a copy of that?
Well, right now, I don't have, madam. You'll find it out, madam.
At 2 o'clock, then bring it.
Yes, madam.
That rule
Amendment rule.
amendment rule when it has come into effect.
Yes, madam.
That is not there in my book. At 2 o'clock, let him get that.
Well,
The last order, don't type it out.
My case, my lord, perhaps I don't know, my lord, I think survive still, my lord, because my case was, my lord, that the advertisement, my lord, which was issued. My lord, that was not in, my lord, conformity with the, my lord, provisions of, my lord, the Assam Public Service Direct Recruitment to Class 3 and 4 post schools 1997. My lord, then there was an affidavit filed, they've taken a stand that the rule will be followed. Perhaps in the meanwhile, I do not, perhaps the entire exercise has been carried out, I don't know, that instruction I don't have, my lord. Is the reason, my lord, that's I'm very sure whether anything survives, my lord. Our case was, my lord, that nothing was specified with regard to, my lord, what will be the marks for the interview, my lord, what will be the marks for the Viva vote, my lord, the written test, my lord. And if at all, my lord, written test will be held. And my lord, what will be the subjects? Now, in their affidavit, my lord, they've taken a stand, my lord, that this will be followed.
There's no affidavit here in this 2258.
Yes, my 2258, my lord, it was filed, my lord, on, my lord. The date is not, my lord, visible, my lord, but it was.
Oh,
filed-
okay, okay, it is there.
Yes.
30 April 2019.
Yes. This one number 2, my lord. Paragraph, my lord, 6, my lord. And,
So in view of this, Mr. Kharunia, in view of para 6, you see that since you have taken a stand in para 6, therefore if the petitioners are eligible, they will be permitted to participate in the selection process.
Here, my lord, I'm praying for some time, my lord. As per my instruction, my lord, this advertisement, the entire selection process has been cancelled by the department, my lord. So, my lord, may I pray for some
Okay.
time so that I can obtain the specific instruction, my lord.
This time the third and the counsel for the petitioner. It is pointed out that this repetition, the subject matter of this repetition is not same as WBC 2024 of 2019. As this repetition relates to claim of the petitioner for being appointed in grade 4 post, right?
well, in fact, my lord, I had challenged, my lord, the advertisement dated 28/2019.
And therefore, the challenge is made to the advertisement dated 28/2/2019. So accordingly, let this matter be listed separately. Next, on the prayer made by Mr. N.J. Khatani, Ramath Standing Constable of the Elementary Education Department. Let this petition be listed separately on 26/4/2023. Just try to get information by them.
Yes, madam. Complete.
Then
May I please your lordship?
Yes,
Madam, this after due vacation.
why?
Land Council, Mr. B.D. Gusami is not present today, and also your lordship, we had not received a copy file, affidavit copy filed by the petitioner.
No, that is for you to ask her. Are you waiting for 2 years to tell us that?
We have filed it on 13/9/2022, Lordship.
And your lordship, respond number 1, 2, 3, 1 to 4, they also didn't find the affidavit.
It's okay. That is why we are here to adjudicate. If nobody is filing, there is not a ground for adjournment.
Lordship, the advertisement was for the post of postgraduate teacher for physics, Lordship. And respondent number 5 is a MSc in electronic science. She is holding the post, Lordship.
Oh, just a moment. First, you service. The land council for the petitioner has not served a copy of affidavit in reply. Oh no, that has been given.
Yes, Lordship, we have given at the time of filing. That's what I'm saying. It's from my class information.
You have to give me one more copy.
Yes, Lordship, I will.
It appears that the copy of affidavit in opposition, affidavit in reply filed by the petitioner was served on Mr. S. Adil and counsel who have earlier appeared for respondent number 5. Right. Wakaratama filed on 3/5/2019. So the records reveal that the respondent number 5 has appeared to another set of counsel by filing a Wakaratam on 28/5/2019. So accordingly, a copy of the affidavit in reply is served on the learned counsel for respondent number 5.
Lordship, he is SLE. His name is SLE.
Your name is Asali.
Yes.
Lord.
Then you can't say that. Then you can't say that. Then we'll have to impose some cost on you for making that statement. You'll be prepared to pay some cost today. Not to be realized from respondent number 5. No, give it to him. Look at the affidavit in reply. The acknowledgement is signed by someone on your behalf.
On that day itself, he received lordship, he filed on 13/9.
So you'll be prepared to pay some costs.
So we didn't receive the copy.
No, then you lodge an FIR against that person who has received on your behalf. But somebody is writing your name and then receiving it. You get a certified copy of the affidavit now. She will not give it to you. And some cost you'll have to pay today. You pay 1,000 rupees to the counsel for the petitioner for the adjournment. You're not happy.
Lordship.
No, sir, it's not our fault. We didn't receive the copies. Okay.
Again, you are making the same statement. She is disturbed with the cost I am trying to impose, and you are repeating the same statement again and again.
My senior counsel is also not present today, so they also instructed me to take time. So,
That is okay, but you made a statement which is false. A false statement I will not tolerate.
I didn't get the false statement also.
4th time. So multiplying the cost. 1,000 into 4.
Also,
This-
I apologize.
This is a practice you have to abjure. Once you make the statement, make sure that you look at the record, you see that it has been served or not. I spent 5 minutes time finding out there's 2 Vakalatma on record. And
I apologize. Also.
and the fact is that once once we received, then you can't take that stand. She is disturbed with the cost I'm trying to impose, and you are making repeatedly the same statement. Acha. Therefore, adjournment has been made by Mr. S. Adil and counsel for respondent number 5 on the ground that the arguing counsel is not available today. First of all, he also submits that copy of affidavit reply has not been served on him. First of all, the said statement is found contrary to the receipt available on record. First of therefore, comma, if the respondent number 5 requires a copy, he will have to obtain a certified copy of the affidavit reply for his purpose. First, matter stands adjourned today. List on 28/4/2023, on which date the matter will not be adjourned on the pair by counsel for respondent number 5.
It's your life.
Well, pleasure.
Lots of the few time examined for handling affidavit lots in this case, also. For 1 and 2 lots.
That's 2 weeks' time.
Lordship.
We done that. Both sides are duly represented. Mr. S. Bhunyal, Attorney Counsel for the Higher Education Department. Place for him is granted 2 weeks' time to file affidavit in opposition in the matter. Post. Affidavit shall be filed at least 2 days prior to the next date of listing. List on 3/5/2023. Just a moment, here is something which I wanted to ask you. We wanted specifically, you may take a note, we will want that, what you call, the marks given to the candidates,
Lordship.
that breakup, that will be requiring.
Yes.
Correct?
Yes.
The lordship interim order passed earlier may be continued.
Okay, interim order passed it is extended till the next date of listing.
My lord, in this case, my lord, all for records will produce the record along with affidavit, lordship. Then lordship, all the marks, how it was distributed, lordship can produce also.
No, you see, Mr. Gogoi, the last time also I tell you. You see, first let the affidavit be there.
Lordship, lordship.
The problem is that if I look at the records,
Lordship.
which contains something
Lordship.
which the other side doesn't know,
Lordship,
he'll have difficulty.
lordship.
You just try to place yourself in this place.
Lordship, lordship.
If I pass orders on the basis of records which you are not aware,
Lordship,
you may be prejudiced at times.
lordship,
Correct? Only that reason.
lordship,
That's why I've verbally told you that this is what I require.
lordship, lordship.
Okay. In the meanwhile, the Learned Standing Counsel for the Higher Education Department shall also be ready with the records.
Lordship.
Just say all sides represented, no? There are other councils also.
May please, Your Lordship, for 30 minutes, this is the second time of the petition. And so there's the date fixed for scan copy.
It is available. You have seen that?
Yes, my lord, I have flag mark. My lord.
Okay.
In the track, my lord, it was found along with the contraband, my lord, of 2000 kgs, my lord, more than 2000 kgs of ganja. There, the investigation after search it filed, my lord.
Okay. What do you have to say?
Lordship, the articles are recovered from the, Your Lordship, from the Jurabat Tiniale on page number 15. And page number 13 is typing copy, Your Lordship, paragraph 3. Place from where Caesar is Jurabat Tiniale, Your Lordship. And articles are loaded from another places. And there have a 2 accused person. And my age is 74 years old, Your Lordship. And I have different kind of illness, and my eyesight is not good, Your Lordship, and for my powerless of my eyes, so I can't understand it what he has loaded, and he has loaded on a darkened places, driver. And Your Lordship, I think that they have loaded the ginger, Your Lordship, because I have a own business of ginger, and before 3 hours. My physical condition is another because for due to my all days, Your Lordship. And the session court is rejected order is page number 23. The petitioner has enclosed a copy on page 25 of the last para, a copy of the order dated 10/2/23 passed by the Honorable Guwahati High Court in case number bail application number 2934/22, rejecting the bail prayer of the accused Ashok Kumar. The Honorable High Court in para 6 of the said order has observed as stated below 6. Notwithstanding the projection made by the learned counsel for the petitioner that the petitioner was asleep in his vehicle when the suspected ganja was loaded. Being the owner of the truck, the court prima facie finds that the petitioner is in conscious possession of the contraband ganja. Because Lordship, when the police was see that is the place of Jorabat Tiniale, and before 2, 3, 4, 5 year hours, my physical condition is another, your lordship. Not so good, your lordship. The physical conditions. And I have no any criminal offenses earlier, your lordship. I have been here of the last page, your lordship. Annexer 35, page 8. This is the character verification certificate. I have submit from the Haryana police, your lordship. And I have submitted some of my medical documents also, your lordship. Page 34A, 34B. And my age is driving license. I have submitted on page 34, annexer 7. Here mentioned my date of birth is 13/4/1949. And the medical documents also, your lordship, their date 12/4/2021. My age is here mentioned is 72, 2021. And the lordship, in this old days, there have no chance for escape from me. And I shall be regularly appeared before the trial court if any condition bail may be granted by this honorable court.
How many days today?
Lordship,
How many days today?
today, he was arrested on 27/10, my lord.
160 days, your lordship.
Okay, we'll go through the records and passwords.
Lordship.
Where is under section 37, lordship, recent judgment in commercial quantity by the honorable high court, lordship, already given in a medical grounds. And my grounds is always in lordship. In a commercial quantity, bail has been granted in a recent, your lordship, by the honorable high court. And the person is the Manipur, your lordship.
Okay, I'll consider this.
Much obliged.
15 for orders.
May please, your lordship. Kindly item number 5, item number 5. your lordship.
Oh, yes.
But I think 15, the review filed by the state, my lord.
No, he is requesting for item 5, that higher education matter. Yes.
Goway's numbers.
Oh, acha.
One is some instruction, present instruction has to take from the lordship. What is it? It is some lordship.
I just wanted to understand.
Lordship.
I'll adjourn the matter, but I'm trying to understand.
Lordship, here, lordship, the issue is that, lordship, the petitioner has challenged the appointment of the respondent, lordship, and he's also challenged his PhD degree, lordship. The fact is that, lordship, the PhD degree also government has taken a decision, lordship, and it was challenged before the honorable court, lordship. As per honorable court's interim direction, now he is getting the lordship increment also, lordship. And regarding that, lordship, the president part also, the petition respondent has challenged his appointment as the president, lordship. That case is also pending, lordship, here. And regarding this particular issue, lordship, more than 18 cases are pending, lordship, court cases they have.
So Lordship, I will give the list of the cases in next day, Lordship, and my lord may take all the matters and hear it, Lordship. And Lordship, regarding suspension, Lordship, one of the pairs regarding suspension also, Lordship, regarding giving the subsistence allowance, that suspension was also put to silence before his honorable court by the respondent, Lordship. As per honorable court's direction, we have reinstated him and now he is getting the Lordship.
I've already passed an order to adjourn it
Lordship.
after due vacation.
Lordship.
Uh, Okay, I just wanted to understand this.
Lordship.
If something, what do you call this? Okay, once you're saying that, I understand, because
Lordship.
there are certain things I couldn't follow. That's
Lordship.
right. Okay.
Even Lordships, all are ego case, Lordship. One case is filed, even Lordship, just I am informed, Lordship, every week, both the petitioners and respondent file a petition. Every week, Lordship, last day, Lordship. Petitioner, especially respondent, Lordship. Every week, Lordship.
Good.
Lordship.
Give that list, we'll
Lordship.
take everything together.
Lordship. Oblige, Lordship.
15 for orders.
Yes. Yes, Mr. Mazumdar.
Little time Mr. Attorney is sitting in the matter. I think 15 madam, 15 and 16.
Review matter.
Yes, just a minute or two.
Okay.
Malad, this is a review prepared by the state, Malad. Here, Malad, the petitioner, Malad, petitioner respondents, she was subject to a screening process, Malad. During the pendency of the writ petition, she participated in a screening process, Malad. Thereafter, Malad, some of them have been accommodated as teacher also, Malad. So may I pray for some time so that I can obtain whether she has been accommodated as teacher or not, Malad. If she has got the appointment, my lord, then nothing survives in the review petition.
No, you see, that can't be. You come to this page 13 of your review petition.
Yes, my lord.
Look at the para 18, second para, sub para 17.
The names of petition are not found in any categories, therefore, transparent petition did not participate in that.
So for that purpose, we can't adjourn because your
Yes, yes, my lord.
review petition is structured on the ground that they did not participate.
The names of the petitioner, my lord, clear. There's only one petitioner, my lord.
So whatever will be,
Maybe.
but there is your stand. Because you see, the basic reason for your review
Yes, madam.
You come to page 14, paragraph 20, that is the only ground. The government is in a dilemma as to whether the direction for payment of salaries to illegal teachers still needs to be paid.
Yes,
That
madam.
is no ground for review.
I've seen many. In any case, madam, today I'm praying for some time, madam. I thought only this is
No,
under
no,
the screening
You see,
committee.
my difficulty is today I had time, I read, I saw something and came. Every day you don't expect me to read and come. Correct?
Yes, madam.
So if I have read it, let me dismiss it.
Madam, I'm praying for only one day accommodation, madam. Day after tomorrow, madam.
Okay. Day after tomorrow, that much I can remember.
Yes,
again.
madam.
But
That is
today
why
is
I'm praying for only one day accommodation, madam.
on the prayer made by Mr. N.J. Khatun, understanding also for the elementary education department. List on day after tomorrow.
16.
This is madam squarely covered with the screening committee decision, madam, because I have the instruction. Some of them have already been accommodated as teacher, madam. Teacher, people. They have accepted the new appointment, madam.
But where is that? I did not find any clarity.
Well, no, madam, I have not annexed here, madam. I have received our telephone, madam. So this may also be fixed on day after tomorrow, madam. I'll produce the list, madam.
No, this goes after vacation because
Yes, madam.
your document over the table, you can't give it to the court. You'll have to file an affidavit.
Yes,
to
madam.
review the
I'll file an affidavit annexing the list, madam.
record. Mr. N.J. Khatun, counsel for the review petitioners, has submitted that he has received some updated instructions and please to allow him to bring it on record by way of an affidavit. Also, prayer is allowed. Matters are adjourned today. List after answering due vacation, by which time the petitioners may file additional affidavit to bring on record the updated instructions.
17.
This is the waiting compliance, well, the read appeal is also dismissed, well.
Yeah, madam, I'm praying for some time, madam, to file an affidavit.
Now you have to comply with the affidavit. The affidavit will not do anything.
The last order was, well, to make payments within 31st, well.
I have seen. Present.
They're without the salaries, well, from 99 and that they've been granted salary from 2008, well, so they've not received any penny, well, so far. These people are suffering.
All these respondents are still there in their office, or you want to impeach someone?
Dr. Vijay Chaudhary. is there.
Yes,
Still
madam.
from there.
This is like it.
Huh?
This is like-
And Dr.
Number 4 is there.
Suranjana Senapati.
Huh.
She is there.
Okay.
The director sees there, madam.
Okay. I'm making it clear, if the compliance is not made, that on the next date you will personally appear, all of you. Mr. M. Dattar and counsel for the petitioner is present. Mr. N.J. Khatun, learned counsel for the respondents, has prayed for some time to obtain instructions and to file affidavit if required. Next paragraph. We take note of the order dated 24/2/2023, wherein this court had recorded that WA 355 of 2022 referred against the order preferred by the state against the order dated 3/3/2017 in WPC 268 of 2013 was dismissed by order dated 20/2/2023. Post. Next, accordingly, it is provided that if prior to the next date of listing, an affidavit of compliance of the order passed in WBC 268 of 2013 is not filed. Comma, the respondents whose personal appearance has not been dispensed with till date shall shall appear in person on 3/5/2023 at 10:30 AM. So the respondent shall take note that if affidavit of compliance is not filed and the respondents are not personally present, comma, the court would pass appropriate orders on the next date to compel their appearance.
In fact, my lord,
Next para, the learned counsel for the respondents shall send a downloaded copy of this order to the respondents, which was constituted notice to them for their personal appearance.
I think I should point out one thing, my lord. In fact, department has moved to prepare an SLP put down on the Supreme Court against this order, my lord.
No, that is okay, because you see,
Yes, no,
I-
that is
I-
that I understand, but this is my duty to inform, my lord.
I'm a student of Order 41 Rule 1.
This is my duty to inform, my lord. That's why I inform, my lord.
41 Rule 1(5) says that unless the Superior Court stays it,
Yes, that I understand, my lord.
you have to comply with it.
Yes. Obliged.
You know, I just recollect an incident which happened long back
Yep.
while I was in practice. I moved an application before the Superior Court
Yes.
for vacating of the leave granted. And the only statement which the court made is, we only admit 5% of the SLPs. So no ground for revoking the leave, and I was shown my way back. Correct. So 5% is the
Sounds my lord.
chance. So in that time till 3rd May, you do something which you have to.
Yes, my lord. Obliged.
18,
Before I start hearing you, I'll take a 5-minute break and come back. Yeah, hearing the matter, Mr. Nath? Oh, sir.
I'm in 19 also. 19.
This is 18.
Matter has already been compromised between the parties. Actually, he wants to submit it last night, they have settled, but formalities are yet to be completed.
Formalities means formality with you or
Formalities,
formalities
sir.
between the parties?
Put the parties because in writing.
Sir,
those things
your
are-
formality is not required.
Milord?
Your formality is not required.
No, actually, you
Okay, your formality is also required.
required.
Okay,
And I have instruction that last night they have come to a conclusion.
okay. Both sides are represented. Mr. R.B. Shah, learned counsel for the review petitioner. And Mr. S. Sahul, learned counsel for the respondents. I submitted that they have received instructions that yesterday the parties have compromised the matter. It is submitted that some formalities are required to be done. Full stop. In view of the joint prayer made, matter stands adjourned today, just after answering the invitations.
One clarification, if those things are not.
No,
done,
you see, if you have that doubt, you please start hearing. Because review petition, I can't adjourn perpetually.
No, otherwise, my lord, what has happened, they are doing this.
No, Mr. Sahu,
Long
you
period.
see, I am very clear. If you compromise the matter, the end of the matter.
My lord.
But if it is not compromised, you please.
But if they go back, my lord, that is why.
No, you see, I don't have answer to that. It is your compromise.
My lord,
I can't make a comment on whether you will go back or not. So if you,
they may go back, that is why.
no, it's okay. Then you hear the matter on merit. You argue the matter on merit.
Yes.
You are ready to argue.
So I'm for the response, he is for petitioner.
Okay,
I shall not go back, your lordship.
No, it's not a question of that. You see, perpetually review matter can't be adjourned. So if it doesn't happen, then you argue the matter.
Will not happen.
Okay.
Public.
Yes, item 19.
I was thinking, sitting in the court, I was thinking, the way lordships conducts, there's no reason that people should go up actually. That's the reason, I don't know. what happened to my lord.
No, one has to go. Because you see, unless people go up, law will not be settled. That is why I have always have a feeling that it is the lowest of the judicial system, magistrate second class or the munsif. Only when they work, law is laid down.
From other way, we think.
Lordship, before my learned senior start, Lordship,
Yes,
Lordship has passed this judgment on 18/5/2022.
yes.
And according, as per Lordship direction, we have prepared the gradation list also. We have prepared, my lord. This honorable High Court order has been complied with. In the meantime, someone has filed it appeal before a division bench. The appeal is pending. Lordship, so,
Is the operation of the order stayed?
no, my lord, no,
No, then there is a second question.
my lord,
You see,
my lord.
in one of the orders I have done it.
Right.
Review jurisdiction
My lord,
is something which is inherent with the with this bench in respect of the the order of 18/5/2022,
my lord,
correct?
my lord,
Now, notwithstanding that an appeal is filed,
my lord.
the jurisdiction of the court to go ahead with the review is available.
my
Yes.
So the corollary point is that if you want me not to proceed with the review, then you will have to apprise the division bench of it.
No, it's well, it's up to Lordship, just I'm informing this appeal.
No,
is-
you see, because that information would not help me,
My lord.
because I can't. The only thing I can't do is that I can't recuse myself from hearing a matter just because the appeal is
Yes,
pending.
Yes, yes. My
And-
lord.
Let me also clarify this point. What happens? So what this particular review applicant is concerned, my lord, he didn't receive notice. So he was not brought to your lordships. Now, technically what happens from our experience, my lord, if this particular applicant goes to the division bench, files appeal, every possibility, lordship normally say, my lord, yes, since you are not heard there, you are, so you know, notice, go and approach the honorable single judge, then you come here. So that's the reason, my lord, this application will be filed. That's the reason. Because there's no bar. Lordship is rightly saying, there's no bar. That's a different issue. Filing an appeal cannot debar your lordship's take a review matter. No.
Because a review will not be available. There is only one exception in the Supreme Court judgments. The only exception, except for that case,
Right.
there's one. The rule is that once the Superior Court or the appellate court interferes with the order, then review will not lie.
My lord.
Obviously, but there's a that matter is disposed of on merit or if the takes appeal. That's obvious, my lord, obvious.
My submission is that lordship, I have to inform this honorable court. That's why I'm informing.
The appeal is on what ground?
Notice has been issued, my lord. In fact, we have, since there is no stay order passed by this division bench, my lord, the department has issued some letter to the authorities to check their ACR report. But in the meantime, the applicant has brought in the notice of this honorable court that they have initiated the process of promotion, my lord. Then we department is thinking we are taking a leave from this honorable court, because as per this honorable high court, we have prepared the gradation list, my lord. Since there is no stay order and there is vacancy also in the department.
Your ground is that the notices were not served.
Notice not served. That's why the fact in related to my case, my lord, could not place it, my lord. And I want to make one thing very clear on the very at the beginning, my lord. I was one of the TF appointees. My lord, I admit, I submit to lordship, my lord. From the date of my appointment, GF, the past period, my lord, I'm not claiming. I'm not claiming because I subsequently, when there was an APSC advertisement, I appeared, I received a call letter, I appeared in the exam. Asked my client, my lord, he said that Guwahati Engineering, that institute, my lord, he appeared there. Anyway, that's a different issue. He appeared, he got selected, his serial number is there, serial number 9 of the APSC list, the recommendation list, my lord. So from the date of, it was recommended, from the date of recommendation, he was regularized. I am saying, my lord, submitting, I'm not claiming the past seniority of 3F because Maharashtra, my lord, that A and B, my lord. That was clarified by Supreme Court in Ogrunath Day. I'm with the lordship there. I'm not on that, my lord. I said my number is serial number 9. The director recruiting, he is a 20, but he probably tried to make out a case that in the recommendation list, that list contains the name of 3 appointees in his name also. How come they'll get senior? But that is the, I think, misconception, because in that recommendation list, you lordship will find there is the roll number of the APSC. We appeared such a just like that particular person, read petitioner Himanshu Das. I also appeared. Same thing we followed. He told me when he appeared in the engineering institute in Guwahati in that exam. Then I asked him, please give me one of your, to be very frank, I asked, give me your roll number or any paper. He said, 30 years or 27 years back, I never knew there'd be a case. That's the reason. But from the list, page 41, that has been wrongly typed again by this petitioner. In the typed version, instead of roll number, he has written serial number. That also creates a confusion. Can we see page 41, my lord?
Yes.
Please select 1 minute, my lord. That's page, select is page, my lord, page 19, page 19. But originally is page 21. Please come to page 21, my lord. I'm take a look at the type version.
Yes.
21, at the bottom left side, kindly see serial number first, my lord. Then lordship kindly see roll number, lordship is in the roll number. That serial number 9 is my number, Deepak Patwari. This has been typed, kindly see, my lord, page 19.
Page 19.
19. Yes. Second serial number. Here, what I have done, my lord, it should be actually not serial number, roll number, that one. We have typed it from the read petition. I told him to wait to verify. He also typed from the read petition, that same thing. In the typing, it has come. It is the roll number of the APSC, actually, my lord. This is what. So I also appeared in the APSC exam. My same examination, read petition, the same examination. Our names are recommended. Petitioner was appointed. I was also appointed, my lord. I am in serial number 9, and rule 24 says lordship is quoted, my lord. Lordship is quoted, my lord, in page rule 4, page 66. Page 66, my lord.
Just now.
In the read petition, my lord, lordship inner page will the type version. I don't want the annexure here, right?
This review is
In out of 3 cases, in 1 case, my last case.
3819. No,
Yes.
3819.
Yes. In 2 other cases, I got any evidence. No evidence. I have Here also I find the read petitioner has typed that as a serial number. It's not a serial number. It's a roll number of that PC. And pursuant to this roll number, they appeared in the exam. Read petitioner also appeared in the exam. I also appeared in the exam. His number is read petitioner is number serial number 20, and I am in 99 minor. Merit position in the recommendation list. And so far, CF regulation, the past service, I am not claiming, my lord. Let me be very honest, my lord. So here I differ with other petitioners, other respondents.
Yes, you look at this. You were respondent number 7. Notice was served on you by Dasti.
By
Dasti. Apart from registered post. By Dasti also. Sending you this.
But that when we file this one, the client says that he did not receive it. Maybe somebody else.
No, maybe.
Yes, Lordship observed all these terms and notice, I remember.
Maybe in the record, sir, because I filed case of
No,
the
that's why I'm showing it to you. Some Bapan Das. He writes for so and so.
For
And
but for my lord.
but in previous page, you'll find in affidavit for 7 and 12, there's a specific statement that it was received by a family member. Down below, there's a paragraph.
Same by them by copy. Copy representation of due receipt the same is being imposed by them excluding national committee. Petitioner a person who went and support the petitioner. Now, in one hand is saying the family members, and there it looks like it is received by the Bapan Das, my lord. Bapan Das. Bapan Das or for him, my lord. I don't know whether I should accept it or not, my lord. Personally,
I don't know. I'll tell you my experience. I was in Golaghat court. At that time, as I was in practice, I was in Golaghat court, and then a fight erupted between the not fight, in fact, verbal debate started between a judicial officer and an advocate. And since it was a loud commotion and I was a new face, so they both wanted me to arbitrate the matter, the dispute, since I was a new face there. Now the magistrate is refusing to sign an affidavit. And the lawyer is impressing upon her that she has to do her duty and sign the affidavit. And she said that I did not understand, therefore I will not sign the affidavit. That is the debate. Then I asked the gentleman, lawyer, that please can you explain it in Assamese, what you are trying to say in English? So you see, the affidavit was that so and so is my is like my son. And he's like my son, he's my son-in-law, his age is 15 years, and so he is written. So
15 years son-in-law.
yes, and therefore I was amazed that he is also a son, he is also a son-in-law, and then age is 15 years. So I told him that please explain in Assamese what you're trying to say. The reply was that no, this boy from very small age, he is living with me, so he's just like my son.
Okay, 1 point about that.
Just like my son, and therefore I'm just filing this affidavit to say that he is like my son, he's legally my son. So that you don't translate in Assamese Laura Nisina in English to make it son-in-law. So therefore, relationship is something which I won't comment.
My lord, my landlord went out and asked the client, who is what is it?
There is no family member with the name of Bakondas. Just now I have inquired him.
But there is the affidavit sworn.
Yes, my lord, but I don't.
And apart from that, the 2 times it was sent by registered post. On first, the return voucher the ID card did not come. But in the second occasion, there is a service note. I'll show you that also. You give that file, I'll show you that.
I've given that.
Oh, achha.
Because he is saying that, my lord, when he received the notice of the writ appeal, then only he has come to know about the proceeding, my lord.
I'll show you that there is also office note
Office note.
of service. Yes, this is the order 10/1/2022. This 10/1/2022 order.
Presumption.
So presumption was drawn. Prior to that, there is a yellow flag. Earlier also it was posted. That is the postal journal for respondent number 7.
Yes. Second.
Yes, but then the AD card was not there. The court directed them to take first steps. So
Right.
twice by registered post
Yes.
and once by way of Dasti.
Yes. But I don't know what to say, but why? I. Only that member is not a family member, that Raju Das or somebody, Bapan Das, somebody, not family members, now
But in the affidavit of service, it is claimed.
by
Then-
family members, but
then
in the
you have to-
affidavit also no specific person like who is received, just family member, maybe somebody. Not specific.
No,
also
I
that-
understand. That's why I told you that story.
That, yes.
Son-in-law.
Yes. Son-in-law. It has become like this almost also.
No, but then you see, in your petition, you have not addressed those things because that's, you will have to make a statement that it was a false statement. Otherwise, your review will not lie.
Actually, about that part we are not aware. That part,
That's why now you have put to notice, adjourn the matter, you take your call.
my God.
Because when I saw these things.
We get that order, yes, on that order, I think.
Additional affidavit.
Additional affidavit, I think, how we can get that now. Additional affidavit.
No, that's why I leave it to you because I merely adjourn it because if that is the fact and being not controverted. I may not be able to accept your statement.
I think in that case, I'll class my client. Will get this order from the website. We'll get it in a story. If he said that. we'll validate it.
10-1 and that affidavit also of service, Dasti service. I have shown it to you. You have read that.
Yeah.
Affidavit of Dasti service. That will have to controvert.
By way of an additional affidavit, I think my lord will make a.
So whatever you do, I
Yes,
just,
yes,
I
yes,
just
yes,
adjourn the
yes.
matter
No, no, not sure.
on your, because otherwise,
Because technically this is a hurdle in between.
because since you are there, I have not dismissed it. On that ground.
No, my lord, no, my lord, not at all. You will also ever feel there is no case openly. But
No,
both will come.
you see, but once you are taking a technical point, better tackle that.
My lord.
But Mr. M. Nathan, Senior Counsel, assisted by Mr. D.P. Baral and Counsel for the review petitioner, as well as Mr. M.D. Baral and standing counsel for the Transport Department, appearing for the
2, 3 and 4, madam.
respondent numbers 2, 3, and 4. Next slide. Having the learned senior counsel for the petitioner. Has submitted that today's notice was brought to the order dated 10/1/2022, passed by this court in WPC 3819 of 2018, as well as affidavit of Dasti service filed by the writ petitioner on 27/9/2021. And he pays for some time to obtain instructions. Mr. Accordingly, matter stands adjourned today. Next, the learned standing counsel for the Transport Department has also submitted that in the meanwhile, against the order against which review is preferred is also a subject matter of appeal before the division bench of this court.
By retrieval number 257,
The WA number 257
2022.
2022. Next, be that as it may. List after ensuing, view vacation,
Lordship may kindly fix the first week of May, my lord.
first week of May, okay, the list in the first week of May 2023.
My lord, basically what I've seen, my lord, personally I see. This openness, my lord, I really enjoy openness. I never feel like, even lordship, remember, when I was in Panchayat,
I always did think myself, my senior, he said, never, you don't stand that you are saving the government. No. So what I used to do, I used to think that I am a state and two persons are fighting for a case and two of them are our citizens. Lordship is passing an order. Either one of the citizens is getting the justice or the other one is failing. But justice is coming from lordships. One of the citizens is getting. I used to take that mentality, my lord. They never suffered from it.
Well, that is true. It keeps your mind relatively, what you call, full.
That's the point. I enjoyed it back those days.
Because if the lawyer takes cases personally,
Yes,
I
very
think if I start taking it personally, it will be a very difficult time.
my lord, what happens? Like now, amongst all my cases, one or two cases I find whenever this is seen the list, I get my top pressure. Because the client become little known to you and they expect so much. In one case, I said I'll return the brief. In the other day, I said I return the brief, pressure so
When you
much.
follow the Delhi policy. Follow the Delhi policy of allied lawyers.
No, succeeded. Except two cases I find. Otherwise, normally it's like
In fact,
Yeah, why not?
my review petitioner is in the zone of consideration. I have been informed by the department that there are 15 to 20 posts are vacant. If that it be, then his position is serial number
11.
11. Then he's zone of the.
Is likely to come in. Okay.
Okay.
I'm deeply obliged, ma'am.
Okay. So I have to rise at 2 o'clock. There is a matter fixed. Yes, so it is degree now.
Yes, madam.
You have a degree.
No, lordship, I don't have a degree, lordship. My contention was that, lordship, since the earlier promotions, lordship, were effected after 2015, they were not being promoted in terms of these rules, lordship. And they were following those administrative orders while promoting those incumbents, lordship. And my promotion may also be given a similar consideration.
But after the rules have been changed, if they have done anything wrong, we can't perpetuate that wrong. On that principle,
The
we,
rules are not applicable. They themselves say that, lordship, at paragraph 7, lordship, of their application. Whereas at paragraph 8, they say that they are following it, lordship. The order of appointment apparently, lordship, would not find that the rules were not applicable, lordship.
some services. No, they are wrong. We'll have to clarify that in the order. That you can't do.
But in fact, this statement that as there is no statutory rules or executive instruction with regard to selection and appointment of the grade 3 post in question, that has been answered in this 97 rules, my lord. 97 rules is a application, my lord. These rules shall apply only to those class 3, both technical and non-technical, and class 4 post where there are no service rules, executive order regulating the recruitment condition of service and are not within the purview of the commission.
No, but it is here. This is already there, Mr. Sharma, as soon as.
Lordship,
You,
but
you
they,
see, you see this recruitment is section 6. Rule 6 of the 67 rules.
Yes, sir. In any case, in 67 rules also, he is not entitled because he has not the requisite qualification.
That is okay. But you can't do it with the direct recruitment rules, because here there are rules for recruitment.
Yes, my lord. That, in fact, my lord, these rules basically for the district establishment. These
Yes,
67 rules.
yes.
And my lord, in rule 6 also, my lord. Rule 6, my lord, junior, by directive on the basis of the competitive examination consisting of so and so, so and so, so and so, as laid down in schedule 1 of these rules to be conducted by the deputy commissioner. Basically, these rules applies to the office of the deputy commissioner.
Which one?
This 67 rules, my lord.
67.
Yes, my lord.
Lordship, may kindly have a look at rule 2, sub rule 4 applies to.
No, this applies to district establishment of all departments.
Yes, my lord.
Does it restrict that it will not apply to?
They will have to adopt it, Lordship, otherwise.
Well, there is no such restriction mentioned in the rule otherwise. But in every rule, here it is mentioned as deputy commissioner, my lord.
Okay.
Under rule 6,
If they do not adopt it, Lordship, then it will not be applicable, Lordship.
Okay. But then why do you say in paragraph 8 about this 67 rules?
because my lord, his case is based on the 67
No,
rules.
no,
my
no.
lord.
You see, his case may be that he is the chief minister of the state.
No, my lord, while answering that his query, my lord, his stand basically, then it is informed. It has been mentioned that
You see, what I'm trying to understand from you is, supposing he makes a claim, today Mr. Sharma is making a claim that he is the chief minister of the state. Correct?
no,
And he makes statements. No, let us assume that he is making it. He is making it. So in your reply, what you will say? You go about answering about whether he stood in the elections or not, whether he was a elected member of the legislative assembly or not. Or you may directly say that since he was never an elected member, he was not appointed as the chief minister by the governor. Why do you go into the election rules then representation of the People's Act and explain everything? What is the requirement here? Either you say that this doesn't apply, but once you say it applies, then he has a point, he has to be considered.
but even if it applies, but he is not eligible, my lord. That is our stand in the affidavit. Though it is not clear that whether which rule has been applicable in that case, but even it is applied since 2015, the requisite qualification is graduation. So, my lord, he is not eligible. So he is only HSLC pass, my lord.
Lordship, the question of the qualification, Lordship, is there only in the rules, Lordship. And earlier promotions were not affected.
No, earlier promotions, I told you that you'll have to demonstrate that what you call the whatever evidence was done was in accordance with Act or rules.
In fact, my lord,
If that is not so, the negative equality can't be claimed.
Lordship, page 32, Lordship. He was also HSLC pass, Lordship, and he got promoted Subsequently, although after filing this case, Lordship, they reverted him, okay, that he is grade 4 post, but that was done only after this.
No,
case was
it's okay. If illegality is pointed out, then they have reverted back.
Yes, my lord.
Okay.
The the educational qualification, Lordship, what the requirement is, Lordship, that if the rules are not being followed, then it's difficult to ascertain, Lordship.
Pardon me?
The educational qualification requisite for that promotion, Lordship, if the rules are not being followed, Lordship, then that doesn't come in, Lordship, or bachelor or degree or graduate, Lordship.
No, that has to be followed because then because the non-following is not in accordance with law. But this matter will still go to the this Commissioner Secretary. Because of this affidavit, we'll have to take a stand. Which recruitment rules will they follow, with the district establishment rules
Yes,
or
ma'am.
this 1997 rules?
97.
They must have a clarity. Heard Mr. MP Sharma and counsel for the petitioner. Mr. also heard Mr. N.J. Khatuniya, Learned Standing Counsel for the Elementary Education Department, appearing for the respondents. In brief, the case of the petitioner is that he was initially appointed as grade 4 staff within bracket Chowkidar by order dated 19/8/1994 in the office of the block elementary education officer within bracket BEEO bracket close Dhokwa Khana. His service was regularized by order dated 16/2/1995. The status of the petitioner was temporarily upgraded as lower division assistant within bracket LDA for short. And it is claimed that till date, the petitioner is serving as in charge LDA. Full stop. The petitioner claims that having served in the BEEO as LDA since 16/2/1995, and having served the department since 19/8/1994, the petitioner has come within the zone of consideration for promotion to the cadre of junior assistant, being a grade C post. Full stop. In this regard, the petitioner had submitted representations on 8/1/2018 before the BEEO, Dhokwa Khana, which was forwarded to the District Elementary Education Officer within bracket DEEO for short, Lakhimpur. Full stop. Although the proposal was forwarded to the Director of Elementary Education, Assam. But the same was not been considered. So nonetheless, on 28/2/2019, an advertisement was issued for filling up the post of 67 numbers of 67 posts of junior engineer, junior assistant by way of direct recruitment. So it is claimed that on when this red petition was filed, about 7 posts of junior assistant were lying vacant in the district of Lakhimpur. Stop. It is also projected that in the year 2014, 2016 and 2017, the Director of Elementary Education Assam has promoted some similarly situated grade 4 employees. And therefore, the non-consideration of the first of therefore, the Learned Council for the petitioner submits that the non-consideration of the case of the petitioner for promotion was violative of his right to be considered for promotion and the same is arbitrary and illegal in view of the discrimination against the petitioner. Hence, by filing this petition under Article 226 of the Constitution of India, the petitioner has prayed for questioning of the advertisement dated 28/2/2019 for the inviting applications for the post of junior assistant. And the petitioner is seeking a direction upon the respondent authorities to consider his case for promotion to the cadre of junior assistant pursuant to recommendation made by the DEMO on 10/1/2018 in terms of the provisions of Assam Ministerial District Establishment Service Rules, 1967. Next paragraph. The Learned Standing Council for the Elementary Education Department has referred to the affidavit in opposition filed by the Director of Elementary Education Assam and it is submitted that under the 1967 rules, the education qualification for being considered for promotion on seniority cum merit basis is that the candidate should have passed degree examination in any discipline from a recognized university or any examination declared equivalent thereto, and must also have rendered at least 7 years of continuous service in the district establishment on the first day of the year in which selection is made. First of all, it is submitted that the petitioner does not have the qualification as prescribed by Section 6 within bracket 6, sorry, not section, rule rule 6 within bracket 6, then small b of the Assam Ministerial District Establishment Service Rules, 1967. You just write in the bracket, the hereinafter referred to as 1967 rules. Most of it is submitted that the provision of rule 6 within bracket small b was substituted, and the previous rule required that the candidate should have passed within bracket high school leaving certificate or equivalent examination. Stop admin record closed. So it is submitted that earlier in point of time, while order dated 15/10/2015, no, sorry, 19/12/2016, Vanshri Dharmeshwar, DHAR, MESWAR, Sutia, CHUTIA, junior assistant, was promoted.
Was a grade 4 employee.
Who was a grade 4 employee, was promoted to the post of junior assistant in the office of DEEO, Lakhimpur. But after the same came to their notice, the Director of Elementary Education, Assam, by an order dated 28/3/2019, reverted back the petitioner to his original post, although he had superannuated by then. There are three names. Number one, Dharmeshwar Sutia. Number two is Jatin Kumar Das. He was promoted by order dated 19/12/2017 in the office of Deputy Inspector of Schools, Dhokwa Khana. Two people, right? Both are reverted back. First off, referring to the statement made in paragraphs 7 and 8 of the affidavit in opposition, committee submitted that the selection process in the establishment of elementary education department is covered by is done under the provision of the Assam Public Services within bracket direct recruitment to class Roman 3 and class Roman 4 posts bracket close rules 1997. And it is also submitted that as per rule 6 within bracket 6 within bracket B, of the 1967 rules, the promotional quota is earmarked as 10% of the vacancies in the concerned district educational establishments. Hence, the standing counsel for the respondents has submitted that as the petitioner does not have the requisite educational qualification, or there is no question of considering the case of the petitioner for promotion to the post of junior assistant. Next. Along with the submission of Mr. Sharma, please add here. The next, the London Council for the petitioner has referred to the case of Nagpur Improvement Trust versus Yadav Rao, YADAO RAO Jagannath, JAGANNATH Kumbhare, KUMBHARE and others, comma, within bracket 1999, 8 SCC 99 has submitted that in the absence of statutory rules governing the service conditions, comma, the executive would have the power to issue instructions and or take decisions in the matter of consideration for promotion. And accordingly, it is submitted that as similarly situated others were considered for promotion, comma, the respondent authorities are required to consider the case of the petitioner for promotion as was done for others. Next paragraph. It appears from the provision of Rule 2 within bracket 4 that within bracket in district establishment bracket close means and includes all non-gazetted ministerial staff in the offices of the deputy commissioner, comma, sub-divisional officers and sub-deputy collectors of the district. And that as per the note appended thereto, the office of deputy commissioner and sub-divisional officers shall include branches like supply, comma, textile, comma, election, comma, revenue, comma, excise, comma, development, and other general branches. So therefore, there's nothing on record to show that that for non-teaching grade 4 staff in the provincialized school under the elementary education department, is covered by the Assam Ministerial District Establishment Service Rules, 1967. It is not known whether the 1967 rules has been adopted by the elementary education department for the purpose of eligibility, conditions of eligibility and appointment. Next para. One of the stand in the affidavit in opposition of the respondents is that the appointments are for the post of junior assistant. By direct recruitment or promotion is covered by the provision of the Assam Public Services within bracket direct recruitment to class Roman 3 and class Roman 4 posts bracket close rules of 1997 bracket with the herein after referred to as 1997 rules.
If that means only relates to appointment and not promotion, lordship.
In this regard, the learned counsel for the petitioner has pointed out that the said rule 1997 rules only relate to the appointment and does not apply for promotion. Hence, it is submitted that it is only under the by applying the 1967 rules that the candidature of the petitioner can be considered for promotion from grade 4 within bracket Chowkidar to the post of junior assistant. Next one.
Lordship, that may not be recorded as my submission, lordship. That applicability of the 1967 rules, lordship. Because I don't have the qualification. As per those rules, lordship, I don't have the qualification.
His entire case based on that matter. Paragraph 13 matter. Page 10. Page 10, paragraph 13. Second line, Malak. But by issuing the impugn advertisement to so and so, the respondents have given clear goodbye to the provision of so and so service rule 1967 as regard the
It's
promotion
okay.
to the post of juniors.
It's okay, we'll have to consider his submission. Just add, however, on a conjoint reading of the 1967 rules as well as 1997 rules, it appears that the other act, 1977 act, continue from there, is for recruitment and not for promotion. Next one. It is not in dispute that both the petitioners, that the petitioner as well as the respondents are both referring to the 1967 rules for one reason or the other. Under the 1967 rules, more specifically, Rule 66B, the grade 4 staff, for being considered for promotion, must have acquired degree certificate from a recognized university and must have rendered at least 7 years of continuous service. So on such parameter, although the petitioner has rendered more than 7 years of continuous service, but he does not have the requisite educational qualification for being considered for promotion. So therefore, the court privacy does not find the petitioner to have the requisite qualification for being considered for promotion. Next, be that as it may, as the director of elementary education Assam, has not only referred to the 1997 rules, but also has referred to the 1967 rules in his affidavit in opposition. To project that as the petitioner did not have the requisite qualification, requisite prescribed qualification of graduate under the 1967 rules, case of the petitioner would not be considered, would not be considered. So therefore, next paragraph, therefore, as the director of elementary education, Assam has referred to both the 1967 as well as 77 rules. The court is of the considered opinion that the matter be remanded to the director of elementary education Assam for a consideration as to whether the as to whether or not the case of petitioner for considering his entitlement to promotion would be considered under the 1967 rules. Or that the recruitment to the post of junior assistant would be made only under the 1997 rules. That is number one. Number two, in the event the Director of Elementary Education Assam is of the considered opinion that the 1967 rules would apply for considering the case of promotion of the petitioner. In that event, as the petitioner does not have the requisite qualification of possessing a graduate degree in any discipline, there would be no requirement to make any further adjudication, save and except to consider whether the petitioner has the requisite qualification. Should I make an observation that he would issue clarification as to which rule will apply?
It is not required, madam.
Not required.
Lordship will kindly make an observation, Lordship, as to when the department has adopted those rules of 1967 lordship by any order or
No,
something.
that is why I have already stated, that is the
Exactly,
first
madam.
question.
Exactly, my lord.
That is the first question.
Which rule
The
is applicable?
direction in number second direction lordship, that requirement may also be incorporated.
No, that is that is what I have done in the first question. He'll examine whether your case has to be considered by applying this case or that.
There has to be some orders or something like that while adopting that
No, not required.
lordship.
Once you see it's a government department, they are consistently taking a stand.
Exactly, my lord.
As you are saying, that on 3 occasions they have promoted someone. Let us assume they have wrongly taken recourse to that.
Lordship.
You see, Mr. Sharma, the approach is, number one, that there is a recruitment rule and he does not follow it. Then we find that it will be a incorrect approach. But assuming there is no rule of the education department,
Lordship.
and they are for some purpose considering the, let us say 1967. So they'll proceed like that.
They-
Because that act itself is not a challenge. Number one,
I mean, not. challenge.
correct. And number two, assuming that he is not following 67, he is following 77, 97.
Lordship.
Then also it is perfectly okay. They did not answer that we have adopted this on so and so date. Because that is being practice being followed. And therefore that itself becomes a good practice.
In fact, my lord, 97 rule is for the purpose of selection and appointment, my lord. Because here we have categorically stated that.
No, but you see, there must be some clarity. That's why I am asking
Yes,
you.
yes,
Mr. Khatria, what is happening? Many people rush to court just because they don't have clarity.
yes, my lord.
Now, if your authorities, they find that recruitment under one rule, promotion under the other rule,
Yes, my lord.
so there may be a chance that one may only think that this is the only rule which is to be followed, 97, and therefore they won't give promotion to anyone.
Yes, my lord. Because in this rule, there is no scope for promotion from grade 4 to grade 3.
So therefore, if that's what I asked you,
Yes, my lord.
if there is some clarification, then at least the people like him will not be deprived.
Yes, my lord.
So we give that liberty to them.
Yes, my lord.
Lordship, why I say it so, because lordship lordship has already read rule 2(4) lordship. It applies to other district establishments lordship. And therein this education department grade 4 stuffs has not been included, grade 4 and grade 3 lordship. So.
That's why in that place only I have said it, it is not covered.
Lordship,
I have stayed there only,
yes, lordship, it's takes better.
correct? Therefore, therefore, it is left to the prudence of the district, the Director Elementary Education Assam to bring about a clarity as to the application of the respective rules for recruitment and promotion, so that it may guide the authorities at the district level to take recourse to the appropriate rule for the purpose of considering recruitment to the post of junior assistant, as well as promotion of grade 4 staff to the promotional post of junior assistant.
Yes.
This one. Next one. Insofar as the case of Nagpur Improvement Trust, relied by the petitioner is concerned, this case is an authority on the point that in the absence of statutory rules governing service conditions of employees, the executive instructions and or decisions taken administratively would operate in the field, and appointment of the promotion can be made in accordance with such executive instructions. Full stop. In the present case in hand, there's no service rules for the grade 4 and grade 3 employees of the employees under the establishment of DEEO Assam. And therefore it is left to the prudence of that earlier part. Then therefore it is left to the prudence of. Okay. The petition disposed of on terms that indicated above. Next para, the petitioner shall produce a certified copy of the order before the Director of Elementary Education Assam, and the said authority shall take a call in the matter and communicate his decision to the petitioner within a period of
1 month.
1 month. 1 month from the date of receipt of certified copy of the order.
Lordship, if possible, one thing may kindly be so Lordship that the earlier promotion order in case of similarly placed incumbents Lordship, therein there is no mention of the ministerial rules Lordship. Therein there is no mention of the ministerial rules of 1967
Okay, I'll add that.
somewhere. Lordship. Maybe. The next case also relates to the same thing Lordship. The dates I'll give Lordship.
You just write in a piece of paper and give it to the
Lordship.
court master. Disposed of. Item disposed of will be item number
7 and 8.
7 and 8.
7 and
Okay. Just that establishment also where is working,
Lordship, I should do that.
your book.